California Civil Procedure Handbook rules, selected statutes and cases, and comparative analysis. Chapter 9, Appeals and Writs. Subpart C, Extraordinary Writs. Demonstrated by the Omaha Indemnity Co. v. Superior Court case, Court of Appeal of California, 2nd Appellate District of 1989. Justice Gilbert gives the opinion. An attorney files a writ petition with the Court of Appeal pointing out an apparent error of the trial court. The Court of Appeal summarily denies the petition. The bewildered attorney asks why. If this case does not answer the question, we hope the following rule will at least assuage counsel's frustration. Error by the trial judge does not of itself ensure that a writ petition will be granted. A remedy will not be deemed inadequate merely because additional time and effort would be consumed by its being pursued through the ordinary course of law. In this action, plaintiffs are suing defendants for negligence. They are also suing defendants' insurance company in a cause of action for declaratory relief. Plaintiffs claim that they are third-party beneficiaries of this insurance contract. The trial court has denied the motion of the insurance company to sever the declaratory relief cause of action, and the insurance company therefore seeks relief by way of extraordinary writ. We initially denied the writ, but after our Supreme Court directed us to issue an alternative writ, we shall now grant a writ of mandate. Background. Real parties Frank and Margaret Grian K. owned rental property in the city of Santa Maria. In July of 1980, the Grenkeys leased the premises to T.R. Treffs and K.R. Treffs and Patricia M. Treffs. The lease agreement required the Treffs to purchase a general liability insurance policy for the mutual benefit of landlord and tenant. In July of 1982, Omaha Indemnity Company, an insurance company, issued a general liability policy to the Treffs. The Grenkeys claim that on or about July 17, 1986, they became aware of damage to their property caused by an oil spill. They contend that the oil spill occurred during the Treffs' occupation of the property. The Grenkeys demanded that Omaha compensate them under the terms of the insurance policy for the damage to the property. Omaha has purportedly denied coverage under the policy. On March 14th of 1988, the Grenkeys sued the Treffs for damage resulting from the oil spill. They also sued Omaha for declaratory relief of other rights under the terms of the insurance contract. I just had to read the procedural history again. In this action, plaintiffs are suing defendants for negligence. They are also suing defendants' insurance company in the cause of action for declaratory relief. Plaintiffs claim that they are third-party beneficiaries of insurance contract. The trial court has denied the motion of the insurance company to sever the declaratory relief cause of action, and the insurance company therefore seeks relief by way of extraordinary writ. We initially denied the writ, but after our Supreme Court directed us to issue an alternative writ, we shall now grant a writ of mandate. Okay, this makes sense now. Omaha demurred to the declaratory relief cause of action. In its demur, it asserted that the Grenkeys were not parties to the contract of insurance and therefore had no standing to pursue a claim for declaratory relief. It contended that the Grenkeys had alleged neither interest in the insurance policy nor in denial of coverage. Thus, Omaha reasoned that there is no cause or controversy pending against it. The trial court was correct in overruling the demur. The Grenkeys alleged that they are the intended beneficiaries of the insurance policy and that Omaha had denied them coverage. In such circumstances, an action for declaratory relief is appropriate. In the alternative, Omaha moved to sever the declaratory relief action from the tort lawsuit. Omaha had denied them coverage. In such instances, an action for declaratory relief is appropriate. Just read that again. Okay, Omaha claimed that it would suffer prejudice should the lawsuit against both itself and the Treffs go forward. Further, it pointed out that severance would promote judicial economy in that there would be no need to try the declaratory relief action should the tenants be found not liable. Yeah, they would be prejudiced. I get that. And they wouldn't have to reach that issue, okay, if the negligence action fails. So, that's a pretty good argument. Although OMA has requested our review of this ruling, it has neglected to supply us with a copy of the reporter's transcript. This did not simplify our task of review. Yeah, you gotta do that for appeals. On August 2nd, 1988, we denied the petition for writ of mandate. On September 29th, 1988, the Supreme Court granted the petition for review. It then ordered the case retransferred to us with the direction to issue an alternative writ in light of Evidence Code Section 1155 and Maradi Shalal v. Fireman's Fund Insurance Companies of 1988. Discussion. A. Motion to sever. Code of Civil Procedure Section 1048, Subdivision B states in pertinent part, quote, the court, in furtherance of convenience, or to avoid prejudice, or when separate trials will be conducive to expedition and economy, may order a separate trial in any cause of action. End quote. In a negligence action, Evidence Code 1155 precludes the use of evidence that a tortfeasor has insurance for the injury that he has allegedly caused. The evidence, quote, the evidence of a party being insured is regarded as both irrelevant and prejudicial to the defendant. From Witkins, Cal Evidence, 1986. Our Supreme Court has stated that the suing of an insured for negligence and the insurer for bad faith in the same lawsuit, quote, obviously violates both the letter and spirit of Evidence Code 1155, Royal Globe Insurance Company v. Superior Court of 1979. Until the liability of the insured is first determined, the defense of the insured may be seriously hampered by discovery initiated by the injured claimant against the insurer. Maradi Shalal again. Quote, it is within the discretion of the court to order a severance and separate trials of such actions, and the exercise of such discretion will not be interfered with an appeal except when there has been a manifest abuse thereof. McClellan v. McClellan of 1972. Although we find that the trial court abuses discretion when denied Omaha's motion to sever, relief by way of extraordinary writ should not be considered a foregone conclusion. B. Relief by way of extraordinary writ. Why it is hard to get and why we initially denied the petition. Approximately 90% of petitions seeking extraordinary relief are denied. See a secondary source called California Civil Writ Practice. Only rarely does the court give detailed reasons for its rejection of a petition. Instead, counsel is usually notified in a terse-minute order or postcard that a petition is denied. Although as a rule the court states no reason for its denial of a petition, it will on occasion refer to an authority in support of its order of denial. This oblique message, ostensibly designed to enlighten, often has the opposite effect and promotes anxiety among those attorneys unable to tolerate either uncertainty or ambiguity. Case law has done little to explain why appellate courts deny writ petitions. The subject is most commonly broached in those cases in which relief has been granted. The appellate court in dicta would briefly explain why extraordinary relief is typically not available. The discussion primarily centers on the unique circumstances of the case at hand and were found to warrant extraordinary relief. So, just as the case law has been disappointing as a source of information concerning the mysteries of the writ, so have attempts to impart information by hierophants of appellant practice. Those who have tried to extract a coherent set of rules from cases and treatises on writs have found it easier to comprehend a washing bill in Babylonic cuneiform. Citing Gilbert and Sullivan, Pirates of Penzance, 1879. A large number of rejections of writ petitions demonstrates that courts will not use their scarce resources to second-guess every ruling and order of the trial court, particularly when to do so would save neither time nor aid in the resolution of a lawsuit. Writ relief, if we are granted at the drop of a hat, would interfere with the an orderly administration of justice at the trial and appellate levels. Reviewing courts have been cautioned to guard against the tendency to take, quote, too lax a view of the extraordinary nature of prerogative writs, end quote, from Witkin, lest they run the risk of fostering the delays of trials, vexing litigants in trial courts with multiple proceedings, and adding to the delay of judgment appeals pending in the appellate court, Babb v. Superior Court, 1971. If the rule were otherwise, in every ordinary action, a defendant, whenever he chose, could halt the proceeding in the trial court by applying for a writ of prohibition to stop the ordinary progress of the action toward a judgment until a reviewing tribunal passed upon an intermediate question that has arisen. If such were the rule, reviewing courts would, in innumerable cases, be converted from appellate courts to nisi prius tribunals. Mitchell v. Superior Court, 1958. Particularly today, in an era of excessively crowded lower court dockets, it is in the interest of a fair and prompt administration of justice to discourage piecemeal litigation. Kerr v. USDC, 1976. That's United States District Court. We're reviewing courts to treat writs in the same manner as they do appeals. These courts would be trapped in an appellate gridlock. This, in turn, would cause ordinary appeals waiting for a review to be shunted to the sidelines. One writer sees a writ petition as being a device used to cut into line ahead of those litigants awaiting determination of post-judgment appeals. From Davis, 1985. The Court of Appeal is generally in a far better position to review a question when called upon to do so in an appeal instead of by way of writ petition. When review takes place by way of appeal instead of by way of writ petition, period. When review takes place by way of appeal, the court has a more complete record, more time for deliberation, and therefore more insight into the significance of the issues. Unlike the ordinary appeal, which moves in an orderly, predictable pattern onto and off the appellate court's calendar, writ proceedings follow no set procedural course. Chernoff v. Watson, writ lore, 1981. Further, some issues may diminish in importance as a case proceeds towards trial. Petitioners seeking extraordinary writs do not always consider that purported error of the trial judge may, 1, be cured prior to trial, 2, have little or no effect upon the outcome of trial, or 3, be properly considered on appeal. Hogya v. Superior Court, 1977. An unrestrained exercise of the power to grant extraordinary writs carries the potential to undermine the relationship between trial and appellate courts. Writ petitions have the unfortunate consequence of making the judge a litigant, obliged to obtain personal counsel or to leave his defense to one of the litigants appearing before him in the underlying case. Kerr v. United States District Court, judges should be umpires rather than players. In order to confine the use of mandamus to its proper office, the Supreme Court in various cases has stated general criteria for determining the propriety of an extraordinary writ. 1. The issue tendered in the writ petition is of widespread interest. Grant v. Superior Court, 1985. So this is kind of the analysis over here. In order to confine the mandamus to its proper office, 1, there needs to be some widespread interest in the outcome of the case. 2, or presents a significant and novel constitutional issue, Britt v. Superior Court. 2, the trial court's order deprived petitioner of an opportunity to present a substantial portion of his cause of action. And that comes from Brandt and also Vasquez v. Superior Court. 3rd, conflicting trial court interpretations of the law require resolution of conflict. Alright, those need to be met for a mandamus to move forward. So 4, the trial court's order is both clearly erroneous as a matter of law and substantially prejudices the petitioner's case. Babb v. Superior Court, Schwieger v. Superior Court, 1970, the prior earlier. Okay. 5, the party seeking the writ lacks an adequate means such as direct appeal by which to attain relief. Phelan v. Superior Court, 1950. In 6, the petitioner will suffer harm or prejudice in the matter that cannot be corrected on appeal. Valley Bank of Nevada v. Superior Court, 1975. Roberts v. Superior Court, 1973. The extent to which these criteria apply depends on the facts and circumstances of the case. Hogia v. Superior Court. To adequately and intelligently decide the issues in this case or any other case, the court must have a complete record. Here we do not have a copy of the reporter's transcript and consequently did not know whether the court had even denied the motion to sever. The minute order states only that the court did not grant the demur. After the Supreme Court remanded the matter to this court at oral argument, the parties stipulated that respondent court had denied the motion to sever. This was helpful, but we still do not know upon what grounds the trial court made his decision. It is true that mandate in certain instances provides more effective remedy than does appeal for the purpose of reviewing an order denying severance. If, however, the trial court here denied the motion for severance without prejudice to bring the motion at a later time, writ relief would be inappropriate. Under such circumstances, the failure to order severance would not meet the definition of an irreparable injury. It would constitute at best an irreparable inconvenience. I disagree, but I also think that this court can discipline the attorney for not giving them a transcript. But anyway, because they could feel like we're answering the wrong issue. Ordway v. Superior Court 1988 is saying that it would be irreparable inconvenience, fine, rather than irreparable injury. Upon proper application at a later time, Omaha may have succeeded in obtaining an order for severance. The trial court is entitled to change its mind before judgment and may vacate a prior order for consolidation and order severance. Okay, I get that. Here, however, there is no indication that the motion was denied without prejudice. The Supreme Court's order directing that an alternative writ be issued constitutes a determination that in the ordinary course of the law, the petitioner is without an adequate remedy. Payne v. Superior Court. Let a writ of mandate issue ordering respondent Superior Court to grant the motion to sever. The stay of proceedings is stalled. So, there's another case demonstrative, but it's very short. Save on Drugs, Inc. v. Superior Court in the Supreme Court of California of 1975. Richardson gives the opinion, that preliminarily it may be observed that the extraordinary writ is not the favored method of reviewing discovery orders. Ordinarily, the aggrieved party must raise the issue on direct appeal from the final judgment. Pacific Tel and Telco v. Superior Court of no date. In Union School District v. Superior Court. The premise upon which this general policy rests is that in the great majority of these cases, the delay due to interim review of discovery orders is likely to result in greater harm to the judicial process by reason of protracted delay, that is, the enforcement of a possibly improper discovery order. Nonetheless, we have concluded that the instant case comes within an exception recognized by Pacific Tel and more recently Roberts v. Superior Court to the effect that we can properly entertain a petition for extraordinary relief when the petitioning party asserts, as here, that to compel an answer would violate a privilege. Alright, so that's an exception. Now, notes and questions regarding extraordinary writs. There's 1, extraordinary writs generally. 2, primer on extraordinary writ practice. 3, alternative and preemptory writs. And 4, statutory writs. 5, types of extraordinary writs. 6, basic writ prerequisites before you get to the end of the chapter, at least. Extraordinary writs generally. Extraordinary writs provide a mechanism for potential immediate appellate review on non-appealable interlocutory decisions of trial tribunals. Writs are extraordinary remedies in the sense that they are speedy and discretionary, and, unlike appeals, do not require appellate review as a matter of right. As Omaha Indemnity Co. v. Superior Court Super demonstrates, writs involve foundational prerequisites not necessary for an appeal. Generally speaking, an extraordinary writ allows a higher court to review actions of a lower tribunal when review by appeal is inadequate. So it kind of seems a little bit broader than the last two cases try to say. CCP 1085, 1086, and 1094.5. Note 2, primer on extraordinary writ practice. A writ is an order entered by a higher court directed at an inferior court, administrative agency, or individual. When a writ is sought from a court of appeal, for example, the process is referred to as petitioning for a writ. The petition is a set of documents which resembles a combination of a complaint and a brief. See CEB, California Writ Practice, drafting the writ petition. There are usually there are three parties to a writ proceeding: the petitioner, the respondent, and the real property and interest. The petitioner is the party seeking relief from the appellate court, and the respondent is the inferior tribunal, usually the trial court, whose decision is being challenged by the petitioner, the real property and interest. Is the party who prevailed in the decision of the trial court. Generally, the real property and interest, not the respondent, is expected to respond to the petition. 3. Alternative and peremptory writs. Writs of mandate and of prohibition may issue as either alternative or peremptory writs, CCP 1087 and 1104. A. An alternative writ is essentially an order to show cause. This writ, when issued, commands the respondent inferior court or agency to grant the requested relief or to show cause why relief should not be granted. CCP 1087 and 1104 again. The issuance of an alternative writ usually constitutes its determination that the petitioner has satisfied the general procedural prerequisites to extraordinary writ review, but is not necessarily a decision for a petitioner on the merits of the petition. For example, Civil Service Employees Inc. Co. v. Superior Court, 1978. The Superior Court issued alternative writ, but subsequently denied peremptory writ. Diamond v. Allison in 1973. Now what? When alternative writ is issued, the requested relief may be imposed on the respondent if no response is filed by the real property and interest. If the real property and interest wishes to contest the proposed relief, the real party should file a response or return to the alternative writ. Interest wishes to contest the proposed relief. The real property should file a response or return to the alternative writ by way of demur, verified answer, or both. CCP 1089, 1105, and Rule 8.490H of the California Rules of Court. This may be followed by a reply or replication from the petitioner, and each party may be entitled to present oral argument. CCP 1093 through 94, 1105, and 1108. If the appellate court then grants the requested relief, a peremptory writ will issue and the alternative writ will be discharged. Example, Brandt v. Superior Court. B. Peremptory writ. A peremptory writ is the reviewing court's ultimate order that respondent must grant the relief requested in the writ petition. CCP 1087, 1097, and 1104. My question is, how soon after a decision can a writ issued? A writ be petitioned for? And since you deny my demur, I can immediately appeal that. But what if I don't immediately appeal that and I wait like a year and a half, but the case is still pending. That's my question. I guess I could look at the rules of court, 8 point whatever, see if there's an answer. 8.490H. This may be followed by a reply or replication form from the petitioner, and each party may be entitled to present oral argument. CCP 1093 to 94, 1105, and 1108. The appellate court then grants the requested relief. A peremptory writ will issue, and the alternative writ will be discharged. Example: Brandt v. Superior Court. B. A peremptory writ. A peremptory writ is the reviewing court's ultimate order that the respondent must grant the relief requested in the writ petition. CCP 1087 and 1097 and 1104, as indicated above. A peremptory writ of mandate or prohibition may issue after the issuance of and hearing on the alternative writ. CCP 1087 and 1104. However, a peremptory writ may be issued in the first instance without first requesting or granting an alternative writ upon due notice. CCP 1088 to 1105. See Palma v. U.S. Industrial Fasteners, Inc. 1984, holding that a peremptory writ should not issue in the first instance unless the respondent and the real property and interest have received notice that such a procedure is being considered and have either filed a response on the merits or been given an opportunity to do so. 4. Statutory writs. Certain extraordinary writs are referred to as statutory writs as opposed to common law writs. Unlike the distinctions between alternative and peremptory or mandate and prohibition, this classification carries little legal significance. A statutory writ is not a distinct type of writ, but is simply one where writ review is specifically authorized for a particular situation by a special statute. Such special statutory authorization for writ review usually contains specified time limitations for filing the writ petition, which may be jurisdictional and should be scrupulously followed. Writ review, specifically authorized by statute, applies to some very important interlocutory decisions, including denial of a motion to quash service of process, and C. Petition for writ of mandate within 10 days after notice of parties to decision. The review of decisions on motions to change venue. CCP Section 400, petition for writ of mandate within 20 days after service of notice of decision. Okay, I think this might be answering my question. Review of mandate is the exclusive remedy here. Is it not? Why? See McCorkle v. City of Los Angeles. Pennington v. Boren, 1966. 5. Types of extraordinary writs. There are a number of different types of writs recognized in California. The most frequently requested appellate writs are the writ of mandate, also referred to by the traditional name of mandamus, authorized by CCP 1084 through 1094, and the writ of prohibition, authorized by CCP 1102 through 1105, 1107 through 1108. Other appellate writs include the writ of certiorari or writ of review, CCP 1067 through 1077, supersedas. That's cute. CCP 923, Rule 8.112, California Rules of Court, and Habeas Corpus Penal Code 1473 through 1508. The California courts are fairly understanding and flexible when it comes to selecting the appropriate writ. Rarely will they refuse relief solely because the petitioner requested the wrong type of writ. See, for example, Anton v. San Antonio Community Hospital, 1977, petition brought as traditional mandamus pursuant to CCP 1085, properly treated as one for administrative mandamus under 1094.5, Babb v. Superior Court. Petitioner sought writ of prohibition, and Supreme Court issued an alternative writ of prohibition. Supreme Court then found mandate more appropriate and treated petition as one for mandate, issued a peremptory writ. Note 6, basic writ prerequisites. As Omaha Indemnity indicates, extraordinary writs are discretionary. The reviewing court is not required to decide the merits of a writ petition or even state a reason for denying an alternative writ. There are some basic statutory prerequisites common to all writs of mandate, prohibition, and certiorari. A. Adequate remedy at law. First, the petitioner must have no plain, speedy, and adequate remedy in the ordinary course of law. CCP 1068, 1086, 1103. Generally, writ review is inappropriate if the challenge decision is immediately appealable. In re Marriage of Skelly, 1976, Phelan v. Superior Court, 1950. An appeal is usually reviewed as adequate, even though it involves far greater expense and time than reviewed by writ. Rescue Army v. Municipal Court, Hogya v. Superior Court in 1977. B. Irreparable injury. The second general prerequisite to writ review, similar to inadequacy of remedy at law, is the petitioner would suffer irreparable injury if the writ is not granted. This prerequisite encompasses several related inquiries, but the main concern is whether the nature of the harm or prejudice is such that it cannot be corrected on appeal. See Roberts v. Superior Court of 1973, use of extraordinary writ held proper in discovery cases where trial court's order allegedly violated a privilege. Person seeking to exercise privilege must either succumb to the court's order and disclose privilege information, or subject himself to contempt for refusal to obey court's order pending appeal. Barrett v. Superior Court. Writ appropriate because if trial court's order is determined incorrect on an appeal, a second trial would be required. Although generally the courts will not find irreparable injury based on the fact that if the trial court's ruling is wrong, the petitioner will unnecessarily incur the time and expense of going to trial. Okay, so can't just use this because a demur failed. Sometimes the courts will find writ review necessary to prevent an expensive trial and ultimate reversal. City of Glendale v. Superior Court, and 1993, bifurcated trial. Smith and v. Superior Court, writ review of trial court's denial of motion to strike emotional distress and punitive damages alleged from complaint held proper because delay of expense of a trial made remedy of appeal inadequate and significant legal issue of importance involved. So that's the end of Chapter 9. The last chapter will relate to the preclusive effects of prior judgments, including res judicata and collateral estoppel, I believe. Yep.